The English rule as it applies to the payment of attorney's fees means that the loser is going to pay the attorney's fees for the other side. That's very different than the American rule. The American rule is that you don't pay the other side's attorney's fees if you lose. You only pay your own lawyer's fees. It's certainly become a very important distinction between the way court systems work in the United States and in the rest of the world. And frankly, you can measure that by the number of lawyers in the United States versus the number of lawyers in other countries that also have bipartisan legal systems. In the United States, being a lawyer is a business, very much so, whereas in other parts of the world it's viewed as a much different type of profession. In the United States, lawyers charge upwards of $2,000 an hour in commercial cities such as New York City, whereas in other parts of the country they charge less, but nonetheless, it's a free market system. You charge what you can to the client. There are exceptions to the American rule. The most obvious are where you have a contract which requires that you pay the other side's fees in the event you lose. About 60% of all contracts have a provision like that. So there are ways that litigants today can accomplish the functional equivalent of the English rule. There's a recognized exception where by statute, a legislature or Congress, for example, decides that a particular type of case merits fee shifting. But the American rule is still the default rule and has been really for hundreds of years now. The impact that the American rule has on the practice of law in America is that cases can be brought which are novel, inventive, cutting edge, and can be litigated without the fear that if you're wrong as a lawyer or a client, you're not going to have to pay the other side's fees in order to test what may be novel waters. That's the benefit of the American rule. But the fact of the matter is the American rule has consequences, and fee shifting does have the effect of having or encouraging a more sober consideration of what you are undertaking before you go into a lawsuit. On the other hand, the prospect of paying the other side's fee can have a chilling effect on less than merited lawsuits. I think the objections to the American rule are based upon commercial realities. The objections to the American rule are most vigorously voiced by those who find themselves having to pay lawyers but not be able to recover the cost of litigation from the losing party. It's an economic reality that litigation in this country is expensive. Lawyers are expensive. Jury trials are expensive if you get there. Because legal costs have gone up so substantially over the past several decades, it is understandable that people would want to look at the economic balance that's created by the American rule. Does the American rule foster the interest that it was set out to accomplish when first established? That is, you don't pay the other side's fees in the event you lose. Is that a good thing?